Good day, Crime Talk aficionados. There's been a lot of talk lately about obstruction of justice. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch. We are not going to get political, but we are going to talk about obstruction of justice. Now, there's been a lot of talk about the Mueller investigation and whether there was any collusion between President Trump's campaign and then any obstruction of justice thereafter. First of all, the word collusion does not appear anywhere in the United States Code. So, if someone is using the word collusion, first of all, they're not talking legal talk, they're talking pundit talk, all right? Collusion is not a legal term. Collusion doesn't appear in the United States Code. You can't collude with somebody. If perhaps they're saying you conspired, well, that would be a different thing. But that would be an agreement between two or more people to commit an illegal act. And meeting with people that may be from another government does not necessarily constitute a conspiracy. So, as many of you know, Robert Mueller was appointed a special counsel to investigate whether there was any kind of conspiracy between the Trump campaign and the Russian government that interfered with the election of 2016. Now, after nearly 2 years of investigation, Robert Mueller and his team, and some people would say that, and this may be actually quite significant, there is an individual that was on the Robert Mueller team that had a very significant role in making the law of obstruction of justice. And because of his conduct in an earlier case, which we will get to and we will talk about it, is why there is no obstruction charges against President Trump. So, Robert Mueller, he's investigated for 2 years. There have been an issuance of some 2,800 subpoenas for the production of documents from individuals as well as third parties, and nearly 500 search warrants throughout the course of this investigation to look at, collect, gather, analyze the information that was in this. I can tell you, ladies and gentlemen, as a criminal defense attorney, after 2 years, 500 witnesses, 2,800 subpoenas, 500 search warrants, if you don't find something that you can indict somebody with, there's nothing there, okay? So let's talk about it. The Mueller report clearly states that there was nothing regarding a conspiracy between the Trump administration and anyone in the Russian government to impede or interfere with the election. So that's a good thing because we all want those type of elections that are free and fair. Now, let's say, has the United States government ever interfered with elections throughout the world? Yes, they have. We'll just leave it at that, okay? Now, so the next issue that the Mueller investigation had to look at is whether President Trump obstructed justice as it related to the investigation for Mueller. The Mueller report gives several examples of what could possibly be construed as obstruction of justice. First of all, steps and comments that were taken by the president to remove the special counsel. Efforts to possibly curtail the counsel's investigation. Efforts to prevent a public disclosure of evidence. Now, what is truly important goes back to a case. Goes back to a case that involves Enron. And as some of you may recall, this may be before many of you people in YouTube land were even born or have any real memories, but there was a energy trading company called Enron, and they made a lot of money. And they were rocking and rolling and really doing a lot of business. But they were using some less than honest accounting principles, and ultimately the delicate house of cards that they had built came crumbling down. When Enron lost basically $1 billion within a quarter, things got ugly. Their accountants, then at that time, Arthur Andersen. Arthur Andersen was one of the big 5 accounting firms out there. They do stuff for all the publicly traded companies. They do all the accounting, the auditing, to make sure the books are legal and Everything's on the up and up. So when Enron collapsed, the federal government began to investigate the accountants who were responsible for the books. Makes sense. So Arthur Andersen, knowing that an investigation was ensuing, retained private counsel instead of just relying on in-house counsel. The outside counsel told Enron's counsel to relay to all their employees that they should comply with our regular policies as related to destruction of documents. That was it. As the investigation proceeded, so did the normal destruction of documents related to Arthur Andersen. Needless to say, Arthur Andersen is indicted for obstruction of justice, not saying they did anything wrong as it related to the actual accounting purposes for Enron, but that they obstructed justice by destroying documents, knowing that there was an investigation ensuing and that they prevented these documents from coming forth. Ultimately, this matter goes to trial. The jury deliberates for 7 days, and ultimately they hang. The court gave a modified Allen instruction. And what the modified Allen instruction is, it's an instruction from the court to the jurors when they have notified the court that they are deadlocked. And it says, go back, reevaluate your conclusions, be nice, be polite, but rethink your analysis of the case. And if you're able to come to a conclusion, great. If you're able to change your mind, great. But don't compromise if you truly believe in your conviction as it relates to that. So after another 2 to 3 days, jury comes back, convicts Arthur Andersen of obstruction of justice. Arthur Andersen ultimately goes belly up. Some 80,000 employees lose their job because of this particular verdict, and probably right before that they were in trouble. The matter is appealed to the Fifth Circuit. Fifth Circuit says, yep, the instructions that were given at the lower court, the trial court, were appropriate. The matter ultimately goes to the United States Supreme Court, and that's where things get interesting. This is for all those true criminal law aficionados here. Now, this is the case why there is no obstruction today. We went over the facts briefly as it related to the Arthur Andersen case. And in the Arthur Andersen case, the indictment alleged that the defendants knowingly, corruptly persuaded another person to withhold testimony or destroy records to be used in official proceedings requires proof of consciousness of wrongdoing. The term knowingly modifies corruptly persuades and thus imposes a mens rea requirement pursuant to 18 United States Code, Section 1512B to AB. All right, what does that really mean? Well, the United States Supreme Court, in a 9-0 decision, reversed the lower court, Fifth Circuit Court of Appeals, as well as the trial court, and it says that they used the wrong instruction. And so in any criminal case, you have the statute that says this is generally what is illegal. But then, whether it be the state or the 10th Circuit, the 5th Circuit, the 1st Circuit, they have what they refer to as their model jury instructions. And so really a bunch of smart people get together and they say, these are the jury instructions, these are the definitions that have changed over time, and they relate to the case law at hand. And so these instructions must be given. And in this jury charging conference, the government tried to say that the word corruptly was not that big of a deal, and that basically, if anyone impeded the government's preservation of these documents, that was sufficient. The trial court agreed, the defense objected. Ultimately, as we talked about, they were convicted. Now, why is this significant? Well, the attorney that led the charge against Enron, the attorney that led the charge against Arthur Andersen, was none other than Andrew Weissman. Andrew Weissman was the trial counsel against Enron. Andrew Weissman was the trial counsel against Arthur Andersen. He was also the right-hand man to Robert Mueller. he was also a paid supporter of Hillary Clinton. Not only contributed to Hillary Clinton's presidential campaign, he was also at the election night party that was supposed to take place that ultimately did not. And in that particular case, Andrew Weissman was also the gentleman on behalf of the government who argued for the lessening of the restrictions as related to corruption. And the Supreme Court, using plain language interpretation, simply stated that the language that was inserted at the urging of the government diluted the meaning of corruptly so that it covered innocent conduct. The actual jury instruction said that Arthur Andersen could be found guilty even if they thought what they were doing was legal. So the United States Supreme Court said that these changes were significant and no longer was any type of dishonesty necessary to a finding of guilt. And it was enough for the petitioner to have simply impeded the government's fact-finding ability. As the government conceded at oral argument, the court noted, impede has broader connotations than subvert or even undermine. And many of these connotations do not incorporate any corruptness at all. By definition, anyone who innocently persuades another to withhold information from the government, quote, gets in the way of the progress of the government, period, end quote. With regard to such innocent conduct, the corruptly instruction did no limiting work whatsoever. The court also went on to say that the instruction was infirm for another reason. They led the jury to believe that it did not have to find any nexus between the persuasion to destroy documents and any particular proceeding. In resisting any type of nexus element, the government relies heavily on Section 1512E1, which states that an official proceeding need not be pending or about to be instituted at the time of the offense. It is, however, one thing to say that a proceeding need not be pending or about to be instituted at a time of the offense, and quite another to say that a proceeding need not even be foreseen. A knowingly corrupt persuader cannot be someone who persuades another to shred documents under a document retention policy when he does not have in contemplation any particular official proceeding in which the documents might be material. So, as in the Enron case, counsel urged them to comply with necessary shredding of documents in compliance with their records. Nobody knew officially that something was coming. They thought it was coming. They thought the investigation was coming, but nothing was initiated. And so for doing what is innocent conduct, you cannot be charged with obstruction of justice. So that is why, and Mr. Weissman is going to be very familiar with this case, because the government did not re-prosecute based upon this opinion. It was a 9-0 opinion by the United States Supreme Court, which basically means everybody, including first-year law students, let alone United States attorneys, should get this, as well as United States District Court judges. That is why there's not going to be any obstruction of justice charges against President Trump. There's no way that they were going to be able to show that there was this corrupt intent to do anything that was done. The president has certain powers under Article 2 to fire employees. He has various privileges that remain. He has various policies that are implemented, and he can do that. And one person could say that is trying to impede. Another person could say that is innocent conduct. If it's innocent conduct, according to Arthur Andersen, you're not going to get a conviction. That's why it's not going to go anywhere. So, not trying to get political, just simply trying to explain the obstruction of justice counts, why they're not going anywhere, what the elements are, and how we arrived at this point in time and the law. Since there has been no charges, which many people in the political world were hoping were going to be filed against the president and that he would be impeached, members of Congress, in their oversight role, have decided to subpoena documents. They have attempted to hold the Attorney General in contempt. First of all, the Attorney General cannot release portions that have been redacted that are subject to the grand jury material unless he receives court approval to do so. He cannot be held in contempt for doing something or failing to do something that he would be committing a crime to do in the future. Many of the congressmen on the House panel have also subpoenaed financial records prior to the president being in office. Literally, as we are filming this, the court ruled that the House Democrats should get the records that they've requested from the president. Obviously, the president is going to appeal. I believe that this opinion is going to be appealed, and based upon that, the appellate courts will overrule the lower court, and this could go all the way to the United States Supreme Court because they're asking for documents that are not related to the time period related to the time that the president was in office. This is prior to when he was out of office. That is not relevant. That is a fishing expedition. When you subpoena documents in court, whether it be Congress, you have to be able to articulate exactly what you're looking for. You can't go on a fishing expedition, what it's there for, and why you need it. That's it. You don't get to just say, give it to me and let me go sort through it. A motion to quash was filed in that particular case. It's going to be appealed, and I've been wrong before, but I believe that the trial court got it wrong in this particular case. And normally, courts rule on the side of not producing documents in a basically general subpoena if you cannot articulate exactly what they're for and as to why they're going to be necessary. So we will watch this in the coming days. We'll also be watching a lot of the cases that are developing, not only in Colorado, but across the country as it relates to crime talk related issues. So I appreciate you watching. Please hit the like button, please subscribe, and hit that little bell notification as well, and leave a comment below. Have a great day.